Trial yesterday was canceled because Karen Reed was ill. Hopefully, she's back today. But since I didn't have any trial video to work with today, I thought we would take a look back at where we are, how we got here, some of the more important things some of the highlights, or I guess in some cases, lowlights of this particular trial. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. I thought we'd start with the opening statement and just how masterfully Mr. Jackson laid out the key element in this about there being no collision.
The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence.
Now, of course, before we got to Alan Jackson's opening statement, we had to sit through Mr. Brennan's opening statement, which is a little bit like somebody taking a really dull spoon, sticking it inside your ear and scraping your eardrum. But be that as it may, I thought it was a long-winded and really kind of ridiculous way to go into this particular case. And the fact that he didn't highlight the weaknesses and say, look, we know this is a weakness, but the other evidence, the circumstantial evidence will cover it. He didn't take the sting out of any of the things that the defense has been steadily beating him up with ever since. And keep in mind, this is in spite of the fact that he's got the judge in his back pocket at this point. I mean, there's really no other way to say it. The judge is clearly biased in favor of the prosecution. I have never seen anything like it in 30 years of trial work. Then there was this rather stunning set of cross-examinations. The Kerry Roberts cross-examination went first.
That was very detailed. You'll agree that that's a very detailed and specific recount of an event. You recounted where you were, back of a cruiser. They were in the back of a cruiser, correct?
Yep.
You recorded or reported the time. It was right around the time that you thought they were lifting John up and scooping him up onto the gurney, correct?
Yep. I thought it was about that time. I wasn't sure.
I'm sorry, I didn't get that answer. You were talking over each other.
That's my mistake.
What was your answer, Ms. Roberts?
I thought it was about the time they lifted him up, but I wasn't sure.
You were very detailed about who was there. It was you. It was Jen. It was my client, Karen
Yes.
Reed, correct? Is that right?
Yes.
You were so detailed that you talked about where you were standing next to the cruiser open door, correct?
Yes.
What the others were doing, holding hands and praying, is that right?
Yes.
And the actual words used. You were as detailed about all of that as the actual words used. She asked her to Google hypothermia and how long, and then you stopped, Google hypothermia, end quote, correct?
Correct.
You will agree, at least for that purpose, you painted a very, very detailed picture in front of the grand jury, didn't you?
Yeah.
Except it's not true, is it?
I did not hear her ask that. I was told she was asked that.
And then, following that, we listened to Jen McCabe.
Courtney Proctor is friends with Julie's sister.
Yes.
And obviously Courtney also knows Julie and Chris, correct?
Sustained.
And there's also a connection to Canton Police Department through Kevin Albert. Is that right? Exactly.
Can you answer that? Is there a connection? Do you have a connection with the Canton Police Department through Kevin Albert? Not with the police department, but Kevin Albert is Brian Albert's brother,
Right. And Kevin works for whom?
the Canton Police.
Thank you. So you've been interviewed many times by different law enforcement agencies, be they Massachusetts State Police, Canton Police, or otherwise, correct?
Yes.
Okay. Those interviews have not just been over the period of weeks, it's been over the period of weeks and months and even years since this occurred, correct?
Yes.
You were contacted by another law enforcement agency that was not Massachusetts State Police and not Canton Police Department at one point in April of 2023. Do you remember that?
Yes.
I want to talk for a second about that series of interview, or that interview. You were contacted at your residence by these members of this law enforcement agency, correct?
Yes.
All right. Later that same day, you did sit down with those same law enforcement officers for a formal interview.
On
On that same day that you were contacted by them, they also went into your home and actually interviewed you, correct?
yes, it was brief.
All right. Those law enforcement officers identified themselves as being associated with an agency that is not Massachusetts State Police. You understood that.
Yes.
And you understood that they were not involved with Canton Police Department either, correct?
Correct.
Completely separate agency, is that right?
Yes.
During the course of that interview, those officers informed you very specifically, Ms. McCabe, that it is a crime to lie to them even during an interview, correct?
Yes.
Those law enforcement officers informed you that they were investigating certain circumstances attendant to John O'Keefe's death, correct?
They were very vague on what they were.
Understood.
I don't know what they were investigating.
But you did understand that it was having something to do with your involvement at 34 Fairview on January 28th, 29th, 2022.
Objection.
As a witness or otherwise?
Objection.
Sustained as to certain terminology, Mr. Jack.
Sure. Let me see if I can rephrase that, Ms. McCabe. You were aware of the subject matter of their interview, right? They weren't interviewing about a car you bought last year, correct?
Correct.
They were interviewing you about, basically, about what you're testifying to here, correct?
When I first spoke with them, the conversation was pretty vague.
But the subject matter, vague or specific, was about this subject matter.
Yes.
Okay, fair enough. And you told them that you had called Kerry Roberts before they interviewed you, correct? At that moment.
I'm not 100% sure, but if you have it,
Give me
it
one-
seems like something I would do, but if you have it, could show me.
Absolutely.
So after that, the judge held a hearing to determine whether the ARCA experts could come in, and I thought that was a fundamentally important part of the trial. Not so much for the argument because Mr. Brennan just showed what a jackwagon he is. Then there was the guy who came in, and he was more or less an unbiased witness, and he laid out the fact that he never saw anyone in Karen Reed's car. And he didn't see anyone lying in the snow underneath the flagpole. And he didn't see anybody in the yard. So if he's not in the car and he's not in the yard, it's only one place left for him to be, and that's inside the house.
Parked at the driveway the entire time, that generally 5-minute time. Did you ever see anybody get out of the SUV and walk down the street towards the driveway?
I'll allow it.
No, I did not, sir.
Did you ever see anybody walk past your truck and up the driveway?
No, I did not, sir.
Did you ever see any person other than your sister outside of those vehicles the entire time that you were at Fairview?
I'll allow it.
No, I did not, sir.
And sir, it took a couple of minutes for Julie to come out after Ricky parked the F-150.
Yes.
When she did come out, you opened the door and you had a conversation with her while she stood between the door and the passenger compartment of the F-150?
Repeat that, please. Sorry.
Sure. When she did come out, she approached the F-150, correct?
Correct, sir.
And you were in the passenger's compartment, right?
Correct, sir.
You opened up the passenger's door, correct?
Correct, sir.
And she you stayed in the vehicle, right?
Correct, I never left.
And she came sort of into like the crook of the door and the passenger's compartment.
Yes, sir.
All right. You had a chance. How close did she get to you?
I could have popped her on her nose if I wanted to.
Okay. And you had a chance to observe her and size her up, correct?
Correct, sir.
You spoke to her for maybe about 5 minutes was your best estimate?
I wouldn't say 5. I'd probably say 2 or 3.
Okay. But in any case, you did have a chance to observe her, correct?
Yes, sir.
And it was clear to you that your sister Julie seemed like she had had a few drinks, correct?
I mean, yeah, it was 12:30 in the morning, so yes.
And she called you for a ride, right?
Yes, she knew that Ricky was driving.
Right. And when you arrived there, there was a discussion about whether she'd actually take the ride, right?
Correct, sir.
If she was just going to come out and take the ride, there would have been no need for the conversation, correct?
Correct.
But do you recall previously testifying that you were out talking to Julie for over 5 minutes?
I would not say over 5 minutes, no.
Okay. Do you deny that it was about 5 minutes?
Objection?
I'll allow it. Do you deny it was about 5 minutes?
Could have been.
Okay.
I'm not.
Fair enough. And you talked with her about whether she wanted to go in the truck and leave with you, correct?
Correct, sir.
You also talked about whether instead you, Heather, and Ricky would go into the house to join the gathering there.
Correct, sir.
There was a back and forth that you really thought was unnecessary, correct?
I wouldn't say it would be unnecessary. It's just a common question if you want to come in and have a drink.
You have testified in the past that Julie can be kind of a pain in the ass, correct?
I mean, all siblings can be, yeah.
In any case, Julie decides to go back inside and you decide to leave, correct?
Correct, sir.
Ricky did not speed up the street at that time.
No.
He just gradually pulled out.
Correct, sir.
His direction of travel took him right past the black SUV that was now in front of you, correct?
Correct, sir.
He passed the black SUV on the left, correct?
Correct, sir.
And you were in the front passenger seat at that time still, correct?
Correct, sir.
So you were closest to the black SUV of the people that were in your vehicle as you passed it, correct?
Correct, sir, yes.
And you were closest to the driver's side of the black SUV, correct?
Correct, sir.
You noticed that the interior dome light was on, correct?
That is correct, sir.
That lit up the whole front compartment of the SUV, did it not?
Yes.
It lit up the driver's seat and the passenger's seat, correct?
All I could see was the driver at the time, sir.
Understood. But the light wasn't just shining just on the driver. It wasn't pointed at the driver.
I would say they were both lights that go down at both seats, correct? They were on.
Yes. Okay.
Yes.
So you could see both seats in the front driver's
I
compartment.
couldn't
correct?
see past the woman.
Well, you only saw one.
I only
person.
saw a woman. Sorry to interrupt you. Yes.
No problem. It allowed you to see into that front compartment.
Yes.
All right. And you saw one person inside the car at that time.
Correct, sir.
Now, having established in some respect that there were things going on in the house that should have been looked at, Mr. Jackson did an exceptional job of putting Paul Gallagher under cross-examination and bringing out some of the real pitches that he missed swinging at when he should have. And the fact that he did what he did, or I should say that he didn't do what he should have done, is, I think, a really important thing in this trial.
While you were spitballing, you also didn't secure the camera footage that we've talked about, the Arlo footage.
Yes, that's correct.
You also didn't formally search the house, correct?
Absolutely
We
correct.
just talked about that. You didn't seek consent by Brian, by Brian Albert to search the house, correct?
That's correct.
You also didn't seek a search warrant. You talked about that, correct?
Correct.
You don't get punished or in trouble if you seek a search warrant and a judge who has to sign the search warrant. Normal citizens can't do that. It requires the judge's signature. You don't get in trouble or get spanked or get slapped or get fined if you seek a search warrant that is denied, correct?
In this particular situation, I would need to articulate facts, certain circumstances, and witness statements. What I had was nobody could put John O'Keefe in the house, including Miss Reed, and that we had a glass where they were coming from a bar, and I had 3 separate police officers, including myself, that had been in that house on 3 separate occasions and saw nothing amiss. I have a good faith obligation to present the truth to a judge. And if I don't, I can be found, end up on a Brady list or a Giglio list, as you know. And my credibility to testify in my career is basically over. So yes, you can get in trouble.
You're talking about lying in an affidavit, sir.
I'm talking about misleading.
Correct.
I would have to twist circumstances to have the right to search Brian Albert's house. We had no reason, and there's been no reason since.
How about this? How about this? There's a dead guy on the lawn that looked like he potentially could have been in a physical altercation. How about that? Might that be of some concern to go inside the house and see if there was a struggle started in the house?
There's still no evidence to go into the house.
You have a guy that's out on the lawn with no coat on. You think the coat might be inside the house? That might be a reasonable assumption. Yes or no?
No.
You got a guy outside with no shoe on. You think the shoe might be inside the house? That might be a reasonable assumption.
I never saw Mr. O'Keefe. I wasn't aware that he
because you
didn't have his
seek
shoes
to find out the details. Other people knew every single fact that I just suggested at the time you walked in the house, correct?
Objection.
Sustained.
The fact is you didn't seek a search warrant.
I wouldn't. Correct.
The fact is you never searched the house.
That's correct.
The fact is you never searched the basement.
That's correct.
The fact is you never searched the garage.
That's correct.
And then we got Yuri Mechanic. Yuri, why are you still a state trooper? That's what we want to ask. You may recall that I went through these 41 things where we established all of the deviations from national standard practices in evidence gathering. This is the extensive list of all of the miscues, mistakes, and malfeasance that I calculated. It runs to 41 of them. 1 or 2 I could overlook, but 41 of these major errors, in my opinion, absolutely underscores how this is ripe with reasonable doubt. And then after that, he got up and he just flat annoyed the jury with his testimony about Proctor's texts and his video time, the lapse in time in the videos.
Chevy Traverse in the upper left hand, the vehicle in the upper left hand corner of the video.
Okay.
Pause it. Let's go ahead and zoom in on the upper left hand corner. Okay. Go ahead and play. Pause. Did you see anything happen with the left rear tire of the other car in the driveway?
Which car are you talking about?
The highlighted portion, the parked car, which is the left rear tire that's zoomed in on.
I wasn't paying attention to the tire. Can you play it again, please?
With the court's permission?
Okay.
Let's try that one more time. Pause it. Okay, you can take that down. Did you see anything happen with that left rear tire of the Chevy Traverse?
Based on that video, it appears there might have been movement there.
Last year, and you've seen this video several times, correct?
I have.
You saw it during the course of your investigation, not just in the course of proceedings, correct?
Right.
Last year, you indicated that you observed the vehicle, Miss Reed's vehicle, come near Mr. O'Keefe's car. Which one in that video was Mr. O'Keefe's car?
The Chevy Traverse.
And that would be the car that was parked and static, not moving, correct?
Correct.
Having seen this, do you still believe that the SUV came near the Chevy Traverse, or do you believe it struck the Chevy Traverse?
With the clarity of that video, there is a lot of movement in the shot. Not with great certainty. It appeared that there was movement of the tire, but I cannot say with 100% certainty that there was movement.
When Yuri finished testifying, when he came off that stand, I would venture to bet that most of the people on that jury just hated him. And judging from my comments, a lot of you did too. When you put all this together, the opening statement with a cohesive, plausible theory of how the Commonwealth framed Karen Reed, the long-winded, poorly organized opening by the state that neglected to highlight the weaknesses in its case, the cross-examination of Kerry Roberts indicating that she'd changed her testimony, and the way she was impeached with her prior testimony, the way that Jennifer McCabe put on what I would call a very poor performance, where she overacted and kept turning to the jury and gesticulating with her hands, trying to sell how much she believed what she was saying. I thought that didn't come off very good for the state. And then Judge Cannoni's decision to allow the defense experts to testify, the accident reconstruction folks, that's a major blow to the prosecution. Now, admittedly, she did keep out the police procedural expert, which is simply something she obviously should not have done. But then the unbiased witness with John O'Keefe being inside the house as opposed to inside Karen Reed's vehicle, because he wasn't in the vehicle and he wasn't in the snowbank. There's only one place left for him. Then Yuri's 41 deviations from the national evidence gathering standards. You put all of this stuff together, and what you wind up with is more than just a little bit of reasonable doubt. Frankly, I thought just Jennifer McCabe's testimony created enough reasonable doubt. But now we have it in spades. It is unbelievable that this case ever made it to trial. I would have thought that any decent, self-respecting district attorney would have told the police to go back and try again. Maybe try somebody else to blame for this, because the job that they did putting this case together is awful. The failure to secure the evidence, the breaches of national standards in evidence gathering, the testimony that comes off clearly as scripted and manipulative. This has not been a good, 14 days, 2 weeks for the state. And it doesn't look to be getting any better as we move forward. That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.